Welcome back. Where do state and territory courts get their power from? Well, the supreme courts of each of the colonies were established before federation. Remember, they were already here. So upon federation, these colonial supreme courts became the state supreme courts. And under section 106 to 108 of the Australian Constitution, that's where they became state supreme courts. Now, most of them are found, or powers exercised are found in state legislation. There's some powers are said to be prerogative or inherent. We looked at that, didn't we, about the power of Parliament, some prerogative powers that weren't explicit, that were said to be left over from powers, prerogatives of the king, for example. So state supreme courts possess these powers. For example, the power to review the lawfulness of actions of the executive branch is said to be such a function. All states except WA have now expressly conferred this jurisdiction on their respective supreme courts by legislation. So another example of the separation of powers being entrenched, whereby state-based supreme courts have jurisdiction to adjudicate on the lawfulness of actions of the executive branch. In addition to supreme courts, each state's got at least one lower court, like a county court or a district court or a local court, and again get their powers from state legislation. The Constitution does have some effect on state-based courts. We've seen section 71 of the Constitution vests the judicial power of the Commonwealth in such other courts as Parliament invests with federal jurisdiction, and section 77 provides that Parliament may make laws investing any court or of a state with federal jurisdiction. So that means that state courts may decide matters arising under federal law if Commonwealth Parliament has conferred power on them to do so. Now, various state courts have been invested with federal jurisdiction, with federal legislation. So the territory courts are slightly different by virtue of they're being established as territories under the Parliament as opposed to standalone imperial states prior to federation. So the Northern Territory and the ACT were established under federal legislation under section 122 of the Constitution, which provides the Parliament may make laws for the government of any territory surrendered by any state to and accepted by the Commonwealth. So after each territory was given self-government, which was in 1978 for the Northern Territory, 1988 for the ACT, the laws establishing their supreme courts became laws of respective territories. So territory courts are not considered courts created by the Parliament, but are other courts for the purposes of section 71 of the Constitution. So like state courts, they can also be vested with federal jurisdiction. How do we go about appointing judges in Australia? It's important because we need public confidence in the calibre of judges and in the independence of the judiciary. So there's a number of different methods for selecting judges. In the US, for example, state judges are elected directly by the people. And the argument there is it's increasing public confidence, their election is transparent, and therefore the judges are more accountable. However, the contrary view would be the politicisation of the courts, eroding impartiality of the judges and their capacity to administer justice fairly and impartially and not be swayed by party politics. In Australia, we do not elect judges. We appoint them. They're appointed by the executive. Most commonly, this is done by the Governor-General General in Council, and as we saw when we looked at the executive, the Governor General and in Council and the Governor of each state is a figurehead role who doesn't actually interfere politically with the mechanisms and does what it's asked essentially by the cabinet. So the government of the day and the cabinet makes recommendations to the Governor in Council, who then acts on them. So appointing judges, non-statutory executive power, we've already looked at that concept. Section 72 of the Australian Constitution expressly confers power to appoint judges on the Governor General in Council. In practice, the relevant Attorney General will make recommendations. There he is, or she is, recommending to Cabinet that they appoint individuals as judges, and then the Cabinet would advise the Governor General whom to appoint. In Victoria, the Attorney General advertises expressions of interest from potential appointees. This members express EOIs, expression of interests, and apply for the role. In other jurisdictions, so at the federal level, Attorney Generals consult senior members of the judiciary and the bar. They don't actually call for applications. And then other jurisdictions have appointment panels or conduct formal interviews as part of the process. So we have laws about the eligibility requirements. There's no express provision that deals with it in the Constitution, but you can understand we need certain standards of our judiciary. So, for example, the Federal Court of Australia Act 76 Commonwealth, that judges must have either been a judge at another court or a legal practitioner of at least 5 years. Now, the current situation has been criticised mainly for a lack of transparency, because there's no public justification as to why Cabinet has chosen the appointment of one candidate over another, and the common language is that the newly appointed judge was selected on merit. Some argue a more transparent process would increase public confidence in judicial independence. Another criticism would be power tends to promote like power, so the current method of judicial appointment lacks diversity in terms of both gender, ethnicity, so the arguments run that we want a diverse bench to, again, instill more public confidence in the independence and impartiality of the judiciary, so that the bench reflects the community it serves, rather than an exclusive segment of it. So in the United Kingdom, 2006, they established an independent judicial appointments commission, which advertises appointments, runs selection processes, and then recommends candidates. Which is another way to do it, isn't it? To have an independent panel. So what do you think? Do you think there should be an independent body who selects, or should it be on the nod of the Attorney General? Do you think there's minimum qualifications? that are expected? And how do we go about making the bench more diverse? Be interested in your opinions. Thanks.